The mother is from Venezuela, got robbed like 3-4 times, basically fled the country, came to the US, and now the son, who is a US citizen, wants to get her the green card. The problem is, she was born in China and she does not have a birth certificate. Getting a green card through your child, through a family sponsorship, you need a birth certificate. It's a primary document. So she reached out to us. We prepared the entire case. They just got the green card. We're so happy to share this success story with you. Let's go. Hi everyone, my name is Joseph. I'm the managing partner here at Tsang and Associates, where we solve legal problems with creative solutions. I have here the entire brief that we submitted, so I'm just gonna read it to you. Our client was born in China in the 1950s, when birth registration centralized systems were practically non-existent. And she is currently unable to obtain a notarized certificate of birth, primarily due to the fact that her parents are now deceased and she is no longer a Chinese citizen because she already moved to Venezuela. Later on, we talk about her situation. We talk about the number of exhibits we provided. We talked about her age. We provided law. We provided analysis. We talk about the timeline and political climate of China in the 1950s. A lot of things change within 100 years, let alone what are the policies of a particular country and a particular region, and whether or not you could get a particular document and can it be certified. But that's what's required in the United States to prove you are who you say you are. But it would be a shame if we stuck to the letter of the law, requiring everything to the T without additional explanation. The beautiful thing about immigration law that I love is the fact that it's so flexible. It is so understanding. And if you're able to prove it, these officers are understanding as well. Page 4, the consequence of denial, in detailed explanation of what this will cause to her, her family, and her US citizen child. Bottom of page 4, page 5, favorable exercise of discretion, why it is good public policy and the interest of the United States to approve a case like this. 27 exhibits just to prove this case. Normal 485 applications, normal I-130 applications do not require 27 exhibits, do not require 5 pages of attorney brief, writing, explaining, going through a history lesson. But in this circumstance, that's what we did, because everything depends on this. She's already been robbed 3 times, right? I think we used that in one of the arguments too. Like anything she had was gone. We used this argument for a different case where their house burned down, right? Everything is gone and she cannot go back and get it. We put everything together. We filed it. We never know what USCIS is going to decide on because it's discretionary. They could deny the case, but if they do, we might take them to court, right? Because it would just be such a bad policy. It's a bad look on the government. We're on the same side here, right? The government, us, and the client, we are on the same side trying to make America great. And so this is what we did. And the client was able to get it. So just happy to share this story with you. Thank you for watching. If you have any questions about your 45 case green card, feel free to reach out. Take care. Bye-bye.